we've talked about liability for costs. And Alison, from what you've said already, it seems to me that you're able, given your expertise, to give a fair indication of the likely costs that the leaseholder is likely to be required to pay the landlord with regard to lease extensions. Yeah, is that?
Yes, I mean, I don't get involved in it nearly as much as the solicitors do, because obviously the conveyancing and completion. But I have an idea of what other people charge, and what certain freeholders charge, so I can have a rough idea to give people. So obviously, as you say at the beginning, they would, unless he doesn't care who gets what, they just care what they've got to pay.
Yeah. And I think the other thing that's important here from a practitioner's perspective is that we need to be careful about giving estimates for costs, because it could be, Alison, that we instruct you in connection with a matter and it's very quickly resolved. The landlord capitulates or we agree figures, job done. On the other hand, you could have a situation where landlord digs heels in, or there are problems with ability to identify landlord, etc., and the sort of the story with regard to the lease extension becomes long and truncated. So from a practitioner's perspective, I always say that you should give a client either an estimate or a ceiling with regard to your legal costs. This is from a transactional property lawyer's perspective, or agree a sort of monthly allowance that can be utilised for costs with a need to go back to the client. But it's impossible, and again, Alice, I'd like your take on this. I think it's impossible in most cases for a lawyer to say from day one, this is what our legal fees will be, because you just don't know. It might be very simple, it might be incredibly complex. And again, there needs to be some form of system whereby you can review costs, or you can agree a sort of an amount that's paid each month with some form of assessment at the end with regard to fees. There's all sorts of things that can be done. What I don't want people to do is to give a quotation or estimate that they're going to be bound by in connection with this sort of matter, because it could be a very simple negotiation and job done. It could be a lengthy sort of dispute leading to tribunal and all that goes with it. So making clients aware of that, but if Alison is able and her colleagues are able to give you an idea as to what the landlord's costs will be in most circumstances, that's really useful. Alison, on the issue of deposit, from a practical perspective, do you get landlords saying, I want a deposit, or is it a question of once you've agreed there's something to be paid, let's just get on with it and pay the deposit and premium at the same time?
Well, the solicitors tend to deal with that when the notices are done. But I do think they do tend to ask for the deposit, I believe. Because, right. Then if they pull out, at least they've got something.
And I suppose the important point about that, Alison, is that if I'm a leaseholder and I know what I'm going to have to pay by way of premium, I might budget for that and arrange funding for that on the basis of closure of the matter. But of course, as far as the deposit is concerned, it is payable during the transaction itself, during the system and process itself. So clients need to be aware of the fact that the deposit could be called upon far sooner than the premium on the basis of finalisation of the matter.